Okay, welcome to this morning session of the Kansas Court of Appeals. I'm Karen Arnoldberger, the Chief Judge of the court, and I will be presiding over this panel today, which simply means I will make every attempt to keep time accurately, which I do not always do very well. So just so you're aware of that up front. I would also like you to know that through Judge Hurst is having a little bit of trouble with her camera. So every so often it just goes off and she has to turn it back on. She can still hear everything at that time and it's only momentary. So I didn't want you to get alarmed when you see that happen. Of course, with me today on your left, looking at the screen, is Judge Gordon Atchison, the most senior judge on the panel today. And then we also have Judge J.C. Hurst, who is the least senior judge on our court. And so we're really happy to be here today to listen to and consider your cases. So I will call the case of 123029 Brad and Cindy Slatten versus R&S Builders, Inc. Would the parties state their appearances, please?
Good morning, Chief Justice Arnoldberger and panel. I'm Andy DeMaria, and I'm pleased to be here representing the appellants and plaintiffs in the underlying case, Brad and Cindy Slatten.
Morning, Your Honors. This is Paul Cowing. I'm pleased to be appearing before your honorable court. I do represent the appellee.
I would let you know that we've read the briefs in your case. We've read some of us have read all the records, some parts of the record, but we do have the record in front of us. If there's anything you want to specifically cite to in the record, we do have that here. I know there was some, I think this is the panel, this was the group that was requesting maybe some demonstrative exhibits, and we sent an email to you in that regard. So with that, Mr. DeMaria, did you wish to reserve any time for rebuttal?
Your Honor, I would reserve 4 minutes.
4 minutes, okay. So you may begin as soon as you're ready.
Thank you, Your Honor, and may it please the court. This is a case of statutory construction applied in the context of when specifically does the Kansas statute of repose begin to run, 10-year statute of repose, for negligence claims against a general contractor, including negligence by omission, not just negligence by affirmative action. I do anticipate that the panel will have questions. I will spend the next few moments just summarizing the bullet points showing exactly why the appellants are correct on the law and why this court should reverse the findings of the district court. The ultimate underlying issue here, the legal claim in question, is negligence. And in Kansas, as a matter of black letter law, and this is straight from Pick 4th, section 103.01, negligence defined. Negligence is a lack of reasonable care. It is doing something that a reasonable person would not do, or it is the failure of a person to do something that a reasonable person would do. And this is commonly referred to a negligent act or a negligent failure, also called a negligent omission. And there were many issues caused by negligence that turned out to be the case in the home that the Slattens purchased in 2014. But upon discovering those things, the Slattens did not sue the individual subcontractors responsible for each individual brick, each individual nail that went into the home. Instead, the Slattens chose to sue the general contractor who built the entire home and was there throughout the building of the entire home. A general contractor must build the entire thing. It has duties in constructing the entire house that continue much later in the course of construction than an individual subcontractor's duties do. A subcontractor, for example, drives the last nail in the roof and then leaves the job, and that's an easy point to determine that's the end of that subcontractor's performance. But the duties and responsibilities of a general contractor go beyond that. The general contractor has a duty to reasonably inspect the work of subcontractors. The general contractor has a duty to reasonably repair or remediate defective work that it finds from its subcontractors. And ultimately, the general contractor has the ultimate duty to the owner of the home to turn over an entire, completed, correctly built home. And the failure to do
I've read the brief and get all that. You're saying that the point that that occurs is with the certificate of occupancy issued by a county official for unincorporated portions of the county, correct?
I am. Yes, Judge.
Okay, and that's really the issue, is that if that's the law, you meet the statute of repose. If that's not the law, your clients are kind of out of luck, basically.
Well, I mean, I think the court has pretty well phrased it correctly. The point in time, the question is, when a general contractor is continuing this series of failures in the original course of construction, how do you know what is, as this court's case law defines, the last original act?
Well, I understand that, and that's what we're trying to sort out. And you're saying it's the certificate of occupancy.
I am saying that. That's right.
Okay.
And that's,
all right.
that is, yes.
As I understand it, and that the Broadhursts, who were the original owners, and coincidentally happened to be the general contractors, but
right.
As the owners, they physically occupied the home on July 13th of 2007, which is before the certificate of occupancy was issued. Right?
That was Mr. Broadhurst's testimony, yes.
Okay. Do we know from the record how that happened? I mean, were they somehow in violation of the law because there was no certificate of occupancy, or is there some intermediate step like a temporary occupancy that was done? What's the record on that?
Yeah, that's a great question, Your Honor. So the record.
That's the only kind of questions I ask.
So
go ahead.
I trained myself to stop saying that. Thank you, Judge. The record is that, and this is Mr. Broadhurst's testimony, that he had obtained a verbal temporary certificate of occupancy from the county at that point in time. And that's when he and his wife moved in. And I think it's important to understand what a temporary certificate of occupancy is. First of all, here it was verbal. So there is no other evidence, proof of any kind in the record other than Mr. Broadhurst's testimony. But even taking that, in the building world, temporary C of O, by its stated, by its definition, means that there remains work to be done. It's essentially the county saying, we know there's work yet to be done by the general contractor to complete the home, because the final C of O is what we ultimately want to grant here. But we're going to let the occupant occupy the home, or at least in this case, in the case of a residence, occupy the home. I think it's a red herring, though, to use that to try to measure the ending point of when the last original act by the general contractor was, because the general contractor, by definition, continues performing or failing to perform beyond the point in time the temporary C of O is issued.
Okay. I'm going to jump and continue. So I'm going to follow up on that a little bit. So basically, you want us, in this case, to adopt essentially as a rule of law for Kansas, that the statute of repose in a construction case begins to run when the certificate of occupancy is issued.
Specific to a general contractor. Specific to a general contractor. That's right.
Okay. Do you know, like, for example, in Republic County, which is like 4,500 people on the Nebraska border, about halfway to Colorado, but not quite, do they issue certificates of occupancy for construction, home construction in unincorporated portions of that county?
Yeah, I can't speak to Republic County in particular. To my knowledge, though, there is some form of oversight for every residence built in this state. Now, for example, this particular house happened to be located in the area of Johnson County that was not incorporated into a city. If it had been in Overland Park might have done the inspections and issued the final C of O. If it had been in neighboring Wyandotte County, that county would have.
I get that, but you're saying you think every other county does that, but you don't really know.
Well, I mean, I'm trying to take the court's question to its logical extreme. If hypothetically there were a county in our state that did not require a certificate of occupancy to be issued in order for a building to be built, would I say that the statute of repose never begins? No. I know that's not the case here.
I guess my problem and the basis of my question is, you're wanting us to adopt this legal rule, and it'll apply across the state if we do that. And I'm trying to figure out, I mean, there are 104 other counties besides Johnson County. Does it work in all of those? And you're saying, well, I mean, I assume so, but I don't really know. Okay, so if there are counties that don't do that, what's the event that would trigger the statute of repose?
And I think to understand that, my answer to that question, it's important to note that the certificate of occupancy, while not an action of the general contractor, is the best measure of the point in time that we're talking about. The point.
Well, okay, but let's suppose we have a county that doesn't do that in unincorporated areas because it's only got a handful of people and they just don't issue certificates of occupancy. What would be the logical thing that would start the running of the statute of repose in that county?
If there is a county in the state that is not using a building code of some kind, then I would have to agree you could not use that as the hard and fast rule in that county. I do not know that to be the case anywhere. And I think what you would do is look at the case law, which we do have, which talks about the last original act in the construction process. What the point I'm trying to make is when there are failures to act that are an issue, how do you find that? And certainly in a county like Johnson County, where we do have building codes in place, that's the obvious point. If hypothetically Republic County doesn't have that, then I could not task Republic County with issuing one just for purposes of starting the statute of repose. But the case law would suggest that you still could look at the last original act of the general contractor in the construction process.
Okay. Judge Hurst, I think you had a question.
Oh, I'm sorry. I can wait until Judge Atchison's done with his.
I've exhausted my great questions on that topic. So.
I doubt that, Judge. So what acts or failures to act were done between July when they moved in and the issuance of the occupancy certificate?
It was a continuation of the failures that had been ongoing to that point in time. The testimony of this general contractor was that this general contractor would hire a subcontractor. Remember, building the house for itself, in effect. I realize there's a corporation and individuals, but building the home for Mr. Broadhurst and Mrs. Broadhurst to live there. That the general contractor would tell a subcontractor, go build the whatever, would let that happen. And then when it was reported that that was completed, the general contractor would hire the next subcontractor, kind of in a very rough schedule kind of a way. There was no inspection of the work. There was no supervision of the work at the time. And as importantly, once the construction is completed, there was no attempt to inspect the integration of each piece of work with each other. Actually, the record here shows that these problems are interrelated and compounded on one another. So without a general contractor in charge of it who was actively inspecting and fixing things along the way, the ultimate job of turning over a correctly completed house could not be done either. So I would say all three of those things.
Can you tell me the date where the application was made for the certificate of occupancy, where it was submitted to the county and said it's complete?
Off the top of my head, I do not remember the date of the application for the CFO. I know it was issued on August 28th.
Would another way of measuring this be at what point was the sale from the general contractor to the owner's final? So did we have a closing date in this case? Or I looked through the record and I wasn't able to locate anything, but is there anything about when this sale closed and the general, basically, regardless of CFOs, when the general turned it over to the owners?
Yeah, and Your Honor is asking that question based on how many times the course of construction and turning over works. I put a footnote on our brief on page 23, it's footnote 2, explaining that in this case, the individual owners, the Broadhurst individually, held title of the house from the beginning point in time through construction. So this was not this was not something where the general contractor literally owned the house. It was, however, like every other construction project, where the general contractor held the duties to construct the house correctly. So the ownership piece did not exist here but the duties on the general contractor did. And that's what I'm
So
interested in.
there was no official turning over of the house to, I mean, they had to, was there payment made to the general, or what were, I mean, was because the general and the owners were the same, it was just kind of all mixed together?
That's what the record shows. Yes.
Okay. Because it certainly would seem like in the normal case, when you have a closing and the builder is turning the house over to you and saying, I'm handing you a working good house, that would be a date that we could all go from, I would think, because you wouldn't care whether what county offers issues certificates of occupancy and which ones don't. But we don't have that here then, right?
No, and what I would also tell Your Honor along that line is I don't want to say normal, in that case that Your Honor is talking about, that date of contractual turnover can't occur until the final CFO is issued.
Right.
It just can't. That's what those contracts say.
Right.
A temporary certificate of occupancy merely allows occupancy. It does not transfer title or affect that closing. So.
Okay, thank you. That answers my question.
Mr. DeMaria, let's say hypothetically, the general contractor feels they're done. The owners or occupants have a temporary ability to live in the house that's been granted by someone. They file for the certificate of occupancy, and because of delay in the county, that's not issued for, let's say, 3 months. So is it your contention that from that 3-month period where the owners are living in the home and have the right to be living there through some sort of temporary order, to the ultimate date, the general contractor would still have, the repose would not start until that was issued, even though it was just sitting in someone's list of to-dos at the county?
Yeah, I would tell Your Honor in that hypothetical, yes. And it's not so much the idea that somebody else is now determining a timeline. It's the matter that legally that general contractor still has the duty to caretake and deal with that house.
The standard on repose, though, is the last act.
Right, but the last act is measuring when does the duty end? When does the duty to construct end? If we're talking about failures to properly construct, then we have to measure the duty to construct on the general contractor, and that would have to be when the county actually gets that piece of paper issued. I appreciate that we're talking about granular level details here, but unlike the other cases that the Supreme Court and this court has issued, where suits are filed 7 to 10 years after the 10-year window ended, so the case is fine. Here we're talking about days. And so I think it's very important to keep in front of us that if we're talking about the duties of the general contractor to construct and take care of that house, then that duty is going to run until the county issues that piece of paper.
So your position is, I believe, that if you had sued the roofer for the defective roof, that the statute of repose would have run if you filed at the same time you filed this one. But is that correct?
I think Your Honor's correct.
Okay.
Right. It's a different.
The thing that makes this different is that this is a general, you've sued the general contractor. And so your point is, at what point, what was the last act that the general contractor did that to cause this damage? And the last act was what? I mean, he didn't approve it. He didn't have anything to do with the certificate of occupancy.
That is correct. That is correct.
I mean, he had to get one, but he doesn't, that's not an action he takes.
It's not, but it is the measure of the date of his last opportunity to repair, remediate the house. After the C of O is issued, the general contractor is off the hook for going in and finding and fixing things. But until that point of time, he has opportunity to do it. His failure to do it is negligence. PIC 103.01.
Right. Okay, thank you.
Why isn't it logical, though, to make that date where the remediation can last be done by the general contractor, the date that the owner of the house either takes ownership or physical possession, at which point the general contractor can't unilaterally enter the premises anyway? Why isn't that a logical place as the last possible date?
In the construction world, the general contractor holds the job, the project, the site until the point of time the C of O is issued. I have asked general contractors this. If you go on the street and ask a random general contractor that, they will tell you that. The general contractor doesn't just get to turn its back on a project until the C of O is issued. That's how it works in the construction world, which is a little different of a world, but that's how that works, Your Honor.
Well, I get that if the county refused to issue a certificate of occupancy for some reason, that the general contractor might be on the hook to fix whatever it was, because they probably contractually agreed with that. But I guess what I'm saying is they can't enter onto the premises at that point without the permission of the owner or the occupant. So why isn't that a logical place to say the statute of repose runs once they no longer have essentially a legal right to enter on the premises because the owners have taken ownership and are physically in possession of the house?
Well, with due respect, Your Honor, I think we're making an assumption that the general contractor no longer has the right to enter premises. The point of fact is they still hold those liabilities.
Oh, I understand they hold the liabilities. You telling me that, like, if I bought a house and moved in, the general contractor could enter without my permission until the certificate of occupancy was granted?
Well, 99 times out of 100, would that be worked out in a cordial way between the owner and the
That's not what I'm asking.
Sure. But yes, I think the general contractor can enter and perform work that the county is telling it still needs to do. I think the occupancy to the owner at that point in time is a courtesy. It's a courtesy offered by the temporary C of O.
All right.
Okay, I have one more question of you. The statute, I'm a little troubled, and the Supreme Court is the Supreme Court. I don't have any pull over what they do, but the statute itself says that in no event shall an action be commenced more than 10 years beyond the time of the act giving rise to the cause of action. This whole issue of putting in the word original and last were words put in by the Supreme Court. They don't appear in the statute. Do you put any import in that at all? At last original act, last act means there must have been an act before that. There must have been a first act Go ahead.
No, so the statute read literally talks about the act. I do agree with that proposition. Interesting note, Your Honor, it does not mention omission. So as far as the omission, negligence by omission goes, I think this court could find, following the thread of Your Honor's question, that, and as my opponent cites at page 13 of their brief, the State v. Kensinger case, saying that the court is not to read new language into a statute. I think by not including the words failure or omission in that this court could find, in fact, there is no 10-year statute of repose for negligence by omissions in the state of Kansas. I think, though, the more harmonious way to read it, the other option, is to read it consistent with what these cases do say, because these cases are measuring series of events that happen originally, and then they are contrasting that to some event that happened way later in time. I think the Dieter case in particular talks about somebody trying to restart the statute of repose. And that's not what this, I think all that the last original wrongful act is trying to do is get a little more granular than the statute does to help determine, to those cases related to a general contractor, when is that exact point in time. Here, I think we've got to go further than that with our microscope, and I think we've got to define it at the issuance of the C of O.
Well, wouldn't the act be beyond the time of the act giving rise to the cause of action? Um, okay, the cause of action is negligence. The act wouldn't necessarily be okay. I mean, I don't think it's as straight. I don't think the reading of the statute is that straightforward as to when you measure. And from what I'm able to gather, this original and last was all put in by the Supreme Court. It was original and last are not in this.
No, those words do not appear in the statute. I agree with that. I can agree with how those cases are written, and in applying them here, I'm simply noting we're now talking about omissions.
Right.
So
Right.
either they apply to those same things and we prevail because we win on those dates, or the statute doesn't include omissions and there's no statute of repose there.
Okay. Any other questions? Okay. I think you're about out of your time, are you? Okay.
I think I am, Judge.
All right, Mr. Cowing, you may proceed.
Thank you, Your Honor. May it please the court. I want to start by just addressing what you said, Chief Judge. Looking at the statute, which is what you have to interpret, obviously, the act giving rise to the cause of action was not the issuance of a certificate of occupancy. It was the work that was done. And as you've been discussing, at the latest time, it would be when the possession was given to the owners of the property. There are, and by the way, Judge Atchison, the appellants were not completely out of luck because this matter has been resolved with respect to the claims against my clients, the Broadhursts as well. Judge Gurney made an appropriate analysis of this and decision, and I point you to his analysis on page 5 when he gave an exposition of the reason for his decision that goes about a page explaining why he said what he said and the decision that he made was appropriate based on interpretation of the statute. I also want to point out a few things that are in the appellant's brief that lead to the same conclusion that I think I'm hearing you suggest. So these are rather telling. In the description of the nature of the case, the appellants say that the general contractor is responsible for the house before turning it over to the owner, which would be, again, more than 10 years before. On page 22 of the brief, it says the general contractor's responsibilities generally run until owner review and acceptance. On the same page, appellants say the work of the general contractor doesn't end until the home is delivered. And finally, on page 20, they say right up that it's right up until the point where the general contractor relinquishes control of the house, which is when the work is finished. The fact is, as you pointed out, the Broadhurst moved into this house with the permission of the county on July the 13th of 2007. Moreover, all of the work that was complained about was complete by May of 2007. The roof, for instance, was done even in 2006.
Mr. Cowing, do you believe, what's your response to there should be a different rule with regards to suing a general contractor than suing each of the individual subs? Because the general contractor has the overall responsibility for making a house habitable and turning over what is expected to the homeowner.
So again, the statute doesn't say the last potential date. It says the act giving rise. And I will point out that here's an example. One of the complaints that was made about the construction of this house was that the deck, which is a massive deck on the back of this house, leaked because under the tile, the ceramic tile that was put on it, there was a rubber barrier called EDPM. The subcontractor that did that work put staples through that and probably should not have done that. That was done well before the time. It was done before and finished before May of 2007. Now, what is it that the general contractor would do between May of 2007 and August 28th of 2007 with respect to that? Because it was not known. What appellants are
Would they
suggesting,
have a duty to inspect
well,
the work
but
of their
all of
subs?
these things that they're claiming there was a duty to inspect would be hidden. There would be the actual negligence occurred, assuming there was negligence, well before the 10-year time period. So it happened in May of 2007 or before that. The claim that there's some duty to, for instance, tear up all the tile or take up the roof and look to see if the felt was deteriorated, those kind of things, does not practically make any sense.
Well, but Mr. Cowing, I mean, the general contractor would have been able to see the rubber underlayment prior to the tiles going on.
And that would be when that act of negligence would occur, when that work was done.
Okay.
Assuming that the general contractor was there and watching and saw that.
So you're saying that the failure to inspect the decking, for example, would have occurred sometime after the rubber went on, prior to the tiles going on?
Certainly more than 10 years before this lawsuit was filed, which would have, by
No, I'm sorry,
admission,
I'm being really specific there.
okay,
So let's say we're talking about the failure of the deck.
right?
If the failure of the deck is related to the holes in the rubber, would it be your contention that the general contractor's responsibility would end once that failure was hidden?
That's the act giving rise to the cause of action under the statute. There is, it doesn't make any practical sense to say, well, it was continuing negligence because no one knew that it had happened, or the general contractor certainly didn't, because before the C of O was issued, he didn't go back and take all the tile up to see if it was done right.
Okay, so then the failure to inspect, the omission, the act of the general contractor occurred sometime between when the holes were put in the rubber prior to the tile going onto the deck, for the deck.
Right, and that all happened before May of 2007, or by the end of May of 2007.
Okay, so, okay.
And look at it this way as well, Your Honor. This keying this time commencement off of the certificate of occupancy doesn't make any sense, partially because of what Judge Atchison suggested about rural counties where maybe a certificate of occupancy never is performed at all. Some work is done, and that's not the key to it. It really is substantial completion, and I'll talk to you about that in a second. But this work was completed well before 10 years before this lawsuit was filed. Let me just mention the cases.
Change gears just real quick. Is the record any more specific about this temporary grant to the Broadhursts to occupy the house in July? Or is there just this sort of passing reference from Mr. Broadhurst that he talked to somebody at the county and said, okay, you can move in? Is that what the record is?
Essentially, yes. Mr. Broadhurst testified that the county building official told him that it was done for the purposes of moving in and allowed them to move in. I think he told him probably like the 10th of July, and they moved in the 13th of July. And,
okay. And this was like a phone call? I'm sorry, like a phone call or something?
I think it was in person. That's my recollection from the testimony. And the small things that weren't done were like, maybe a handrail outside or something like that. But they didn't have anything to do with the claims that are made in this case. So
I got
if you look at the case law and then look at the statutes that council's relying on from out of state, the Massachusetts, for instance, says that the 6 years runs on the statute of repose from the opening of the improvement to use or substantial completion of the improvement. New Mexico says 10 years from the date the construction is sufficiently completed so the owner can occupy or use the improvement. They all talk about substantial completion. Utah says completion is the earliest of the certificate of substantial completion, certificate of occupancy issued by a governing agency, or the date first use or possession of the improvement. So even under this Utah statute, which is very specific, and by the way, all of these statutes that are cited are specific to improvements in real property, not like the Kansas statute, which the title of which is actions limited to 2 years, which has a statute of repose that applies to all actions concerning that time frame.
I just wanted to follow up. There is no document in the record here that is a temporary certificate of occupancy. I mean, there's no written thing from the county that's the Broadhurst could move in July.
You're correct.
It's purely oral.
You're correct.
Okay.
And Mr. Cowing, is that something that everyone in that area can obtain? Just an oral temporary certificate of occupancy? Do you know the standards for getting that? Is the standard substantial completion?
A presumption on my part. It seems I don't think there was any special treatment in this situation. There's certainly no evidence that there was any special treatment at all. And I would be surprised if it were.
When RNS building, RNS Building Inc., they have general oversight over the construction project. Was there evidence presented as to when, for example, if the people that did the deck were one of the problems, when RNS Building paid the deck people? Meaning, I would assume when RNS Building paid them, RNS is saying, we're accepting your work.
Right. That's accurate. I mean, if the record does show when, in fact, there was even an inspection of the roof, that the work with respect to the stucco and then the work concerning the back deck, which involves a number of items, including the staples through the EDPM, all of that was done and paid for well before July 13th of 2007. In fact, it was all finished and I believe all paid for by May of 2007.
And that's all in our record?
I believe it is.
We don't have a whole lot in our record that I see as far as
I believe that in our
invoices or anything like that.
Oh, I don't know that there are copies of documents that say that, but there are statements that
Was there testimony in the record?
There are statements of fact that are not denied, that they are in fact admitted with respect to these issues.
Okay.
And I think those will answer your question, Your Honor.
Okay.
I could go on, but I will tell you that Rhode Island and Ohio and Wyoming all say the same thing with respect to, quote, substantial completion. They do not, my partner just texted me and told me that what you were asking for, Judge, is in our summary judgment pleadings, at least.
Okay, all right.
Those are part of the record. So, this is the Wyoming case, for instance. In the principal opinion, it says our task is to interpret the language our legislature utilized, which of course is your same issue. Giving the words their plain and ordinary meaning, we conclude statute begins to run on the date the owner can utilize the improvement for which it's intended. If our interpretation of the plain language is not what the legislature intended, it's free to amend the statute. And in the dissent, Judge Fox or Justice Fox says to find that the improvement is not substantially completed until issuance of a certificate of occupancy is to put words in the statute that are not there, contrary to our rules of statutory interpretation. What appellants are asking you to do is put words in the statute that aren't there. And this is clearly a legislative prerogative. So
Mr. Cowing, I don't want to interrupt you,
No,
but I
please,
do
go ahead.
want to clarify.
no problem.
So it sounds to me that you agree with appellant that the start date for a general contractor might be different than it would be for the sub.
Certainly,
statute
it is
of
at the
repose.
latest date, it's when it's substantially completed. And that would be when July the 13th, 2007 to July the 13th of 2017 in this case.
Do you think going on your substantial completion, there's usually some sort of checklist or something like that related to substantial completion, I think. And theoretically, issuance of a temporary occupancy certificate would maybe also indicate that. Of course, as Judge Atchison points out, we don't have that here. So is your proof of substantial completion here the mere fact that they moved in?
With the permission of the building official. And again, I'm not conceding that the act giving rise to all of the complaints in this case related to work that was done, all of which was completed by or before May of 2007. So this lawsuit should have been filed at the latest by May of 2007. And it was filed August the 28th of 2007. I respectfully suggest to you that, again, Judge Gurney's explanation and his decision were completely accurate and the right decision in this situation. And if the suggested changes in the law that appellants are arguing for should occur, they should be done in the legislative branch of the government. Appreciate your time, and I
Thank you, Mr.
appreciate your
Powell.
questions, Your Honors.
Thank you. Mr. DiMaria, you have your 4 minutes of rebuttal. You're on mute.
Thank you. Thank you, Your Honor. That final line of questioning, I think, only highlights the problems with the current state of the district court's ruling. And that is, as Your Honor has pointed out, that each individual item of work, if you're going to measure it off of when a subcontractor finished nailing that item of work, would have its own individual 10-year statute of repose. Although that might make sense if I'm suing the roofer for the roof and the deck builder for the deck, it makes no sense to have that myriad of statute of reposes operating when I'm suing the one party whose task it was to produce the entire completed house. We have to look at the point in time of the entire completed house.
Okay, let me interrupt you then for a minute. But if your issue is that the negligence on the part of the builder was failure to act, didn't the general have an obligation to inspect the work of each subcontractor before writing them a check? Or so if the problem with the deck was something that the subcontractor did during the course of building the house and could not have been seen with the naked eye after the tile was put on, didn't the builder have, or didn't the general have a duty to inspect the work as it was being done? Because if it wasn't quality, wouldn't you think that when they paid them, that's the general's acceptance of that work?
One would think, and one would think that regarding that subcontractor's right to receive payment, that yes, that general contractor would in fact perform an inspection by that time. But looking the other way, Your Honor, to the duties that general contractor has onward to the owner and to subsequent owners, that duty and that failure to inspect continues. He didn't inspect it the next day. He didn't inspect it the next day. The check is written. Now we're on day 3. He's still not inspecting. In fact, we get to the point in time where the general contractor loses an ability to go in and do any inspection. When the certificate of occupancy comes down, that was the last point in time when that original wrongful series of acts ended. So yeah, I appreciate what the court is asking about payment, but I don't think that's the question regarding liability down upstream to the owner.
Okay, but are we constrained by the Supreme Court's interpretation of this statute as being the last original act? I mean, what is meant by original? Original seems to indicate there could be several last acts, but we're looking at the original last act. So one last act may be the builder signing off and a certificate of occupancy being issued, but maybe there's one before that, because the Supreme Court says we have to look at the original last act. So was the original last act the failure to inspect the deck before it was completed and
No.
signed off on? Okay.
The failure to build the deck was the last original wrongful act of the deck builder, that subcontractor. The last original wrongful act of the general contractor is that last point when they failed to do anything to correct problems in the house. That's my point about it's a different party and it's a different duty.
Different standard. Right.
Yes, Your Honor.
Okay, thank you.
Did that help?
Yeah, it did.
In conclusion, Your Honors, I think that Kansas deserves a bright line rule here. I think that this statute can only be read in a way that with the evidence in this case and with the parties in question, not subs but their general contractor, we have to find that RNS Builders' last original attempt that it could have acted and failed to was when the certificate of occupancy was issued on August 28, 2007. Thank you, Your Honor.
Thank you. Anything further from the panel? Okay, thank you both very much. This is a fascinating legal issue for us to dive into, and we appreciate your briefing and arguments today. And we'll get a decision out to you as soon as we can. Thank you.
Thank you.